She is currently a senior research fellow at the Institute of State and Law of the Slovak Academy of Sciences, with main focus on international economic law and international investment law in particular. She works also as an associate professor at the Faculty of Law of the Pan-European University in Bratislava. As a former banker, she served in 2008-2009 as an arbitrator with the Permanent Arbitration Court of Slovak Banking Association and is currently listed as an international arbitrator in the Israeli Chamber of Arbitrators. She is member of Chartered Institute of Arbitrators, UK, the member of Congress of Fellow with the Center for International Legal Studies in Salzburg, Austria, the member of American Society of International Law, the member of the Society of Advanced Legal Studies, UK, and the member of the Czech Society of International Law. Associate Professor Chovancová has already published more than 100 studies on international investment law, the international commercial and investment arbitration in Slovakia, the Czech Republic, Hungary, Austria, and the USA, and the Netherlands. She is the author of several monographs on the subject of international commercial investment arbitration. So now I invite Associate Professor Chovancová to start her lecture, and good time to hear to her. Thank you. Floor is yours.
Thank you very much, Professor Koma, for giving me the floor, and also thank you very much for such a nice introduction. Now, I just hope that you all can hear me and we won't experience any difficulties with not being able to hear well. Actually, the topic of the day is the force measure and its importance in contemporary international investment law. Before I deliver my essay, this was just a joke, of course, I will shortly introduce the topic of my speech, which is the force measure and its ever-expanding importance in contemporary international investment law. It is a topic of ethereal beauty, both from the viewpoint of the theory of international law, as well as from the viewpoint of practitioners, legal counsels, judges, and arbitrators. But before going into the nitty-gritty about the force measure from all its angles, I will draw your attention, just very shortly, to the structure of my lecture. I've divided my talk into three main parts, and I aim to speak for about 45 minutes. I hope that I will keep you as intrigued by the topic discussed right from the start as at the very end of my speech. Better than starting with the definition of the force measure, it would be too obvious. I will begin with indicating what the force measure is unable to secure, because it is strong on the surface, no doubt about that, but as you will see, not all the way through. So it's not a magic talisman. It can't always be invoked to avoid contractual obligations that have become too difficult to perform. Definitely, the force measure, universally valid, doesn't exist. Quite opposite, in fact, as today we may distinguish three its variations already in international law. It has its origins in the Roman law, being pretty much tied together with the principle impossibilium nulla obligatio. That means no one is obliged to do the impossible. And it is really impossible to mistake it for its younger siblings, such as, for instance, the doctrine of impracticability, which is quite typical for the US, or a bit older English frustration of the contract, or a restrictively perceived act of God, distinctive for common law since 1581, in spite of the fact that all these doctrines are applied in practice in connection with unforeseeable and uncontrollable situations, which is impossible to avert, not even with the maximum efforts made. And this is an undeniable fact, although all these doctrines are sometimes quite unreasonably generalized in international legal writings, being considered as notions which cover just one notion or would have often simply become known as the force majeure. According to the US Supreme Court Justice Holmes, the duty to keep a contract means a prediction that you must pay damages if you don't keep it, and nothing else. This is rather a strict statement. An obligation of contractual performance, following the reasoning of Holmes, would thus mean with 100% guarantee that in case of any breach of the contractual provisions, the party breaching on the contract should always be obliged to pay the damages. On the other hand, it is necessary to remember that this statement formed a part of the theory of the law of contracts Holmes authored in 1897. In those times, the force measure used to be applied under the well-spread legal theory as a doctrine of municipal law, which has been transferred to international jurisprudence to enable state to escape liability where it otherwise would be responsible, with the highest goal being escaping this responsibility for what? For national disturbances, for instance, or even a civil war. For instance, the obvious example of the armed conflict at those times, capable of being described as a force measure, had become the Civil War in the US. But on no account, this meant that every civil war was a consequence of the force measure in the 19th century, of course. At the same time, the force measure was relied on also within the frame of the claims, which were filed in connection with an unsatisfactory protection of foreigners in their host states. And accordingly, it was perceived mainly as a descriptive term. It described something. It described an unhappy external event which constituted in specific cases, yes, external events such as the Civil War in the US, I've already mentioned. However, a comfortable labeling of external events as force measure in all cases where an active participation of state, which was a bit disappointing, the violator of international obligation was impossible to overrule unless being completely blind, it didn't do any good, both for international community and also for international law. As a result, the use of force measure in international public law was looked down on a bit in the 19th century, having been seen partially with a pinch of salt and leading to the following lack of trust with respect to its use in the private sphere, in private law, in contractual force measure clauses. At the beginning of the 20th century, the force measure has become an independent legal term, not the descriptive term anymore. And it was marked in its restrictive form as an act of God, as one of the causes of quite sophisticatedly defined supervening impossibility, referring, but not only, to contractual obligations. In theory, when one was under a legal duty created by the contract or otherwise, and the performance required of him became suddenly illegal or objectively impossible, the duty was expunged. Apparently, lex non cogit ad impossibilia had its considerable weight as much in 1922 as today, 100 years later. Today, the force measure has been widely accepted as a fairly classical topic, and the circumstance excluding wrongfulness of the state doing a majority of the world legal systems, and it is frequently deemed to be one of the basic legal principles with meta-juridical character, as the idea at the heart of force measure pleas has deep roots in human thinking about morality and responsibility. When considering international investment law, it may be submitted that together with necessity, which is another circumstance excluding wrongfulness of the state's act in international law, the force measure today belongs to the most frequently applied circumstances excluding wrongfulness in international investment disputes between host states and their foreign investors, and we can say it is almost the quintessence of the defense, for instance, in investment arbitrations in an energy sector and the E&P industry, which is an extraction and production industry. Unsurprisingly, both concepts were conflated casually in the past because of their similarity. With respect to the scope of applicability of the force measure in substantial areas of international law, It has been observed that the level of its use has increased considerably in the last decade, regardless of the influence of the COVID-19 pandemic. Force majeure has been used in international arbitration practice, in investment disputes between host states and their foreign investors as a circumstance excluding wrongfulness of the state act in accordance with the customary international law under the ILC draft articles on the responsibility of states for internationally wrongful acts adopted by the UN International Law Commission in 2001, but also in case of armed conflict or civil disturbance, or as already mentioned, force majeure contractual clause with a definitive list of events of force majeure. So the parties, the contractual parties, agree what the force majeure event is going to be according to their contract and nothing else. This is a big advantage of the contractual parties. Following traditional common law concept, because in common law we didn't have the definition of the force majeure. And this force majeure clause is embedded in investment contract entered into directly by an investor and, for instance, the state entity of the host state. Similarly, the force majeure will be of use in protection of the foreign investor in international investment arbitration, commenced or started, simply put, on the basis of the bilateral investment treaty. At the same time, we shouldn't forget that even if an increase of the popularity of the force majeure application in international investment law has been a relatively recent issue, perhaps you'll notice we traveled back to the 19th century, the basic pillar for all deciding international investment tribunals when it comes to conditions and consequences of ascertaining the force majeure defense in international disputes is without hesitation an exceptionally rich and resource of jurisprudence of the Iran-US Claims Tribunal. This important international tribunal, since its establishment in 1981 under Algiers Accords in order to settle the grave crisis in Iranian-US relationships, has been up to now considered one of the biggest mechanisms of international dispute resolution when considering, for instance, the number of decided cases, which is really huge, and the amount of financial claims submitted both by Iranian as well as by the US nationals. So the force majeure is very often used also in international investment disputes that arise between foreign investors, international oil companies, and their host states or their national oil companies from so-called governmental agreements in extracting business in connection with extraction and production of oil and natural gas. A similar use has paved its way also into the energy sector, for instance, in Iraq, in Libya, in Russia, and Belarus, in all cases in which the government of the whole state has created so favorable conditions, but this is meant, of course, ironically, for investors that the only thing they can do is either risk, namely, violation of imposed economic sanctions, and trying to continue dutifully with performing their contractual obligations, or with some common sense, to refuse to cope up with the contract, to abide by it, although there is then, of course, the contractual liability. It is thus only logical that in a majority of international commercial, except for investment contracts, we will certainly find a precisely formulated drafted force majeure clause in which the parties to a contract expressly allocate the risk when they define what constitutes a force majeure, or eventually they will rely on several model force majeure clauses. An opposite tool is, for instance, the ICC force majeure clause in its latest version from 2020, and the IAPA model force majeure clause, which is popular in international extracting industry. And this is the persuasive proof of adaptation of the force majeure clause to the needs of international commercial community. Because, of course, this community is much broader than the international investment community. By the way, it is exactly an adaptation of the force majeure clause in favor of both these communities, which has recently resonated quite vividly, no surprise, in relation to the COVID-19 pandemic. The long and tiring pandemic we've all experienced for a long time, compared with the most classical force majeure event of enormous natural disaster, has enlivened the concept of force majeure and also hardship significantly, and especially in long-term contracts. The reason naturally has been lost proportions of the pandemic as a global crisis, with a very negative impact on international contracts, with the prophecy of a rapid increase of international investment and commercial disputes. As commentators have noted recently, the COVID-19 pandemic will generate, and of course this is not a very optimistic preview, years and if not decades of post-pandemic litigation and arbitration focusing on the application of these two concepts, both the force majeure and also the hardship. The pandemic has a serious impact also on dispute mechanism of international investment, crisis management and resolution techniques. New tools have been launched with success, and all investment and international commercial arbitrations have become literally virtual or easy. Energy sector was seriously hit as well, as the crisis struck the oil market during the early stages of the pandemic. But essentially, then every sector of the energy industry has seen rapid and also dramatic shifts flowing from changes in commercial relationships and government policies instituted to address impacts of the pandemic. From the start, the significant decrease, an expected decrease of international investments in energy sector has been anticipated. So it has been expected. Unfortunately, then later it has become reality in all its parts, while particular damage has been done especially to the extracting oil and natural gas industry and also in the electricity sector. At the same time, it has raised specific questions in international private law, while triggering out the parliament debate about COVID claims with regard to state responsibility for its wrongful conduct in international public law. So the statement of Judge Holmes now, it has perhaps lost its appeal already. If we take into account a current use of the fruitful force majeure in international law, where it is exactly the force majeure, which is that something else, which can be suitably applied by the contractual party in some absurd situations, specified in the contractual force majeure clause. As a matter of fact, the force majeure is unique. It really is. First, when applied as a circumstance excluding the wrongfulness under Article 23 of the ILC articles, its application, unlike in case of necessity and countermeasures, excuses an international illegal acts of the state which is involuntary. And this is something you should remember. It excuses, it doesn't justify, it excuses because it is an excuse. Second, its variability is second to none as well. Nowadays, it will be applied in three variations. First, as a circumstance excluding the wrongfulness of the conduct of the state under the ILC articles. Then, as a circumstance claimed in connection with reviewing the appropriateness of the due diligence, care, and finally, as the force majeure clause, the contractual provision in international investment and classical international commercial agreements. A contemporary development of force majeure is equally extraordinary, as the period of its most dynamic development, this is something I've already mentioned today, was the 19th century, when the basic pillars of the protection of foreigners in host states have been established by the International Minimum Standard or the IMS. And it was exactly during that time when all four elements of force majeure were gradually formed, out of which two today, namely unforeseeability and sometimes also irresistibility, which is the impossibility to avert an external event, they are mocked a bit ironically from time to time because of, for instance, climate changes. In truth, an inevitable question is what at all, and after all, can be marked today in our times of accurate seismic measurements unforeseeable at all, when an extreme weather is a new normal, and with all the state-of-the-art technical equipment, what can be really defined as inexorable or incontrovertible? Now moving to the historical development and the basic characteristics of the force majeure. Historically, an expansion of the use of force majeure, as I already noted, excusing the wrongful illegal state conduct goes back to the 19th century. And it is intertwined with, far from being satisfactory protection of foreigners within the whole state territories, which resulted in various conflicts the states have been unfortunately unable to prevent. While the dispute arisen were being solved at first by diplomatic means and later before mixed special commissions, the states tried many times to escape their own responsibility and, except for manipulating with the international minimum standard, they somehow on the way discovered and snatched instantly the force majeure defense, which became literally their innocent victim, because these states, the culprits, turned to it in an alibistic manner in order to get an excuse of their own illegal acts, literally from bombardment till armed unrest. So this extreme practice of the states has been condemned by many states, an epiphany indeed, though they focused by mistake more on stressing the causing of the harm and damage by the whole state instead of tracing the causal link between the force majeure external events and the damage caused. And of course, this didn't help a lot to shaping its definition. In contrast, on the other hand, this practice certainly had its positive aspects because it helped to form the basic elements of the force majeure excuse, being an externality, irresistibility, which is unavoidability, and unforeseeability, which were later worked on by the UN Commission for International Law in the process of codification of the circumstances excluding wrongfulness of the wrongful conduct of state in the customary international law. In addition, those disputes proved to be a very fertile ground for the development and finessing of the law of responsibility generally, but also for the consolidation and some configuration of the concept of force majeure in interstate relations. The force majeure thus has been gradually changed conceptually from the descriptive term to the legal rule concerning an impossibility of performance in which the predominant role was played by the free will of the state, not an arbitrariness, and also an impossibility of performance, material as to the kind, and absolute with an extraordinary possibility of the latter level through the relative impossibility of performance. If the state didn't abide by its international obligation voluntarily due to an external event with specific elements, the force majeure as the state defense was at the violator's disposal, though being frequently exercised in practice in the first half of the 20th century, the force majeure still wasn't codified, but neither the states nor the ILC Commission had ever doubted its importance. The force majeure was thus posited and put without hesitation in the codification process among 5 circumstances, excluding wrongfulness, of the state conduct in international law in the first report of the UN Commission presented by Professor Majeure in 1956. Later, in 1979, the 8th version of the same report defined the force majeure as the circumstance excluding wrongfulness as one concerned with the impossibility to perform an obligation due to the occurrence of an external event, be it natural or anthropogenic, which was unforeseen or irresistible. So as you can see, the definition of the force majeure was getting its own shape. Nowadays, the force majeure is codified as one of 6 circumstances excluding wrongfulness of the state conduct, together with the consent, self-defense, countermeasures, distress, and necessity. And the Article 23 of the ILC articles, which is a respected codification of the customary international law in all its partial questions regulated in the articles. Circumstances excluding wrongfulness under ILC articles pertain equally to an internationally wrongful act of state, which incorporates the violation of the state obligation contained in the general international law rules, as well as the violation of obligations from international treaties, unilateral acts of states, and so on. The purpose of their application is not the termination of violated obligations, no, but an excuse of non-performance of international state obligations while the circumstance excluding wrongfulness lasts. Under Article 23, Section 1 of the ILC articles, the wrongfulness of an act of a state which is not in conformity with an international obligation of that state is precluded if the act is due to force majeure, that is, and here we have the definition. This is the occurrence of an irresistible force or of an unforeseen event beyond the control of the state, so it is absolutely uncontrollable, making it materially impossible. As you can see, this is the material impossibility which is required in the circumstances to perform the obligation. Article 23, Section 2, in turn, the use of force majeure excludes if the situation of force majeure, this external event of force majeure, for instance, tsunami, is due either alone or in combination with other factors to the conduct of the state invoking it because of the lack of prevention, for instance, or the state has assumed the risk of that situation occurring. Here, of course, relying on the force majeure defense would be irrational and also against good faith. A typical element of the force majeure, derived from its very definition that you just heard, is an absolute absence of voluntarism, stressed with the qualified irresistible force under Article 23, Section 1 of the ILC articles. Irresistible, incontrovertible, unavoidable, inexorable. The state can't avoid it. The state will not breach on its international obligation because, for instance, it contemplates this could be to its advantage, or just drifts into the abstract in terms of how it sees the possible consequences of its doing. No, the state will violate international law here because of just one reason, because it has no choice. It may be implied then that the force majeure arises because the state is compelled to act in conflict with its own international obligations. And this compulsion, being compelled to act, is of record a much better term than coercion because it has a slightly criminal undertone, which I personally don't find very appealing. With regard to unforeseeability as another element of the force majeure, an unforeseeable event under Article 23, Section 1 of the ILC articles cannot be only unforeseeable, but at the same time of such nature which cannot be foreseen easily. Otherwise, it wouldn't be controllable by the state, the violator, which is the next element of the force measure under Article 23. So while fulfilling the criterion of uncontrollability, it is irrelevant here whether we are talking about an external event or the real deeds or omission to act of those obliged. The essential element in a force measure event is not whether the acts of the state, the violator of international obligation, or omissions of the state when the violation is caused by omission to act by the state, are those of the obligor or external to him, but rather the fact that such acts or omissions can be attributed to him as a result of his own willful behavior. So it's really not the fault of the state. Although it is an abstract meta-juridical nature of the force measure, which is tied together with it firmly, while the force measure excuse is taken for granted as a traditional inventory today in international law, the force measure itself is a permanently developing concept and is very attractive both for legal scholars, also for practitioners, and it's very practical and relevant in many situations that the states are facing. Probably the most frequently mentioned example of these situations is an irresistible natural force, for instance, tsunami, a hurricane, tornado, flood, the drought, and so on. The number is higher in practice, and this is true also when it comes to the practice under Article 23 of the ILC articles, while an applicability of the force measure clauses in international commercial contracts may be even broader, as long as it copes up well with obligatory provisions of the governing law of the contract and the principle of bona fide, that means the principle of good faith. As for applying the force measure under the ILC articles in international public law, it is necessary to distinguish it from the contractual force measure clause in international commercial practice, as well as from the supervening impossibility under Article 61, Section 1 of the Vienna Convention on the Law of the Treaties. Similarly, while the force measure in international commercial contract clause is going to be drafted in accordance with the parties' autonomy, with probably terminating the contract as one of its consequences, the purpose of the application of the force measure under Article 23 of the ILC articles is a temporary excuse of illegal state conduct conflicting with its obligation under international public law. So as you can see, the purpose differs here a bit. In connection with the purpose of force measure as a circumstance excluding wrongfulness, I cannot omit a polemic debate in international legal writings with regard to its classification as an excuse or a justification of violation of international legal obligation. The latest theories tend to classify the force measure as an excuse because the plea of force measure is individualized. It focuses on the state rather than the act and on whether the state acted voluntarily when it failed to perform its obligation. So an involuntariness of illegal conduct, the fact that the state had really no other choice but to violate on its international obligations, due to an absolute absence of the free choice to act caused by an irresistible force, and here it is necessary to stress the physical involuntariness, understandingly doesn't contain an element of free choice within involuntariness as a normative concept. And that's why an application of force measure under Article 23 of the ILC articles has been accepted from the start as a state defense against responsibility for violation of international obligation, and within the broader prospect of the state responsibility in international law, which is based on existence of the free will, where the state has a capacity to act normally, it is possible to conclude that if this capacity to act normally has been disturbed by compelling or coercing that state to act involuntarily, the state may be excused from the legal consequences of its illegal conduct And this is, after all, the meaning of force majeure, being supported exactly with the theory of the free will of the state. Thank you very much for your attention.
Oh, that was an erudite and very elaborate presentation on the subject. In the meantime, our director has joined, and it's my pleasure to introduce Dr. Madhuri Parikh, Director, Institute of Law, Nirma University.
Hello, Professor Professor Katarína. How are you?
Oh, I'm fine. The weather in Austria is nice because I've been living in Austria for 10 years, happily near the Slovak border. So I'm fine. Thank you very much. And thank you very much for your invitation. I'm glad to be here again.
Thank you for the session.
And now I invite questions from the participants. They can type in the chat box.
I just take your leave now because I have some work, so I'll have to leave the session.
Oh.
So,
Okay.
okay.
So participants may type their questions in the chat box. We are left with enough time. And participants should also fill up the feedback form. Please type your questions. Nayanika Singh asks to please clarify the distinction between justification and excuse with respect to the force majeure clause.
Actually, this is something I've already covered in my lecture. An excuse makes an act of state when the force majeure is perceived as an excuse and accepted as an excuse of the illegal state's conduct in international law. This act won't be considered illegal actually from the start, from the beginning, because this conduct will be excused due to an external event and the state had no choice and other choice and so on and so on. But when it is perceived as a justification, that means that this conduct will be considered actually illegal, but for some reasons it will be justified. This is the difference. And the difference is also where the focus is put. When the force majeure is understood as an excuse, the focus is on the state, not on this illegal act, and on an involuntariness of the conduct of the state. While justification is a bit different concept. That's why it is better to understand the force majeure concept as an excuse than the justification of the illegal conduct.
I'm waiting more questions from participants. Please type your questions. Please type your questions. So, if there are no questions, I will not hold the professor. Please type if anybody has to ask any question. Yes, there is one. The question is, in case of calculation of liquidated damages, some states prefer a prospective or first approach method where they fix the amount in case of damages suffered. In an event of force majeure, how come such issues be addressed when it comes to damage calculation?
I think it will depend on actually which force measure is applied. Whether the force measure is applied as a defense against illegal conduct of the state under Article 23 of the ILC articles, we are talking about the force measure clause embedded in the contract, then it's absolutely up to the parties. I think that the author of the question perhaps had this application of the force measure in mind. So I would say that it is up to the parties how they calculate their damages and define how the damages are going to be calculated in the contract, because it's up to them. It will be done in accordance with the parties' autonomy in the international commercial contract or the international investment contract.
Does anybody have any other question? So in case there are no questions, I would thank Professor Chovancová for joining us today and delivering such a beautiful lecture. I'm sure our students are benefited, and it was a pleasure listening to you. Thank you very much, Professor.
Thank you very much, Professor Kumar, and thank you very much also to Professor Srivastava for a perfect organization of the whole event, as always. And it was a pleasure for me, of course, to lecture within the international teaching lab organized by the university. And I was very glad to see such a high number of participants we don't experience actually in Slovakia. So it was, I was really glad to be here. Thank you very much. Thank you.
Thank you, Professor Chovancová, and hopefully next year you'll be able to come us and meet us.
Yeah, that is what we dream of.
Well, I've never been to India. I would love to travel to India. I can tell you. So of course it will be my pleasure.
It would be a pleasure to host you, Professor.
Thank you.
Thank you.
Bye.
Yeah.
Bye-bye.
Thanks a lot.
Bye.